Good afternoon, everyone. Sorry to interrupt the conversation. First of all, we'd just like to welcome you here today. We know it's a pretty drizzly day, so we do appreciate you coming to join us. In this session, Patrick and I will discuss a few learnings or insights that we've gauged from the first PID annual return, and also from some of the requests for information and or advice that Patrick's team in particular has received. So in terms of introductions, my name is Marianne Bregovic. I manage the audit and monitoring section of the PID unit at the New South Wales Ombudsman's office, and I'm delighted to have Patrick here with me today, who manages the advice team. In terms of some of just notices, PID Awareness Week sessions will all be recorded, as was mentioned earlier today. If you have any concerns about your images or the recording of the session, please make it known to our staff. And in the event of an emergency, please follow the instructions and follow the exit signs to the nearest assembly point. So without further ado, we'd like to start with an acknowledgement to country, and I'll pass over to Patrick to do that.
Thanks, Marianne. So as Marianne said, we'd like to start by acknowledging that we're meeting on Aboriginal land, and we recognise that many of you are joining us from different Indigenous lands around New South Wales. The New South Wales Ombudsman acknowledges the traditional custodians of the land on which we live and work. We pay our respects to all elders past and present, and to the children of today who are the elders of the future. We extend that respect to our Indigenous colleagues who join us today. We also want to recognise the important role that the New South Wales Aboriginal Land Council and local Aboriginal land councils play as stewards of culturally significant lands, as the hearts of their communities, and as forces that drive development for their people.
Thank you, Patrick. Well, most of you, if you've registered for any session during this PID Awareness Week, you'll know that the core theme or focus is on a speak up culture. And that's what we'll start off with today. I think it was mentioned in the session earlier this morning that good government relies on us all as public officials coming forward and speaking up when it's necessary to do so. And one core object of the Act is that it promotes a culture where PIDs are encouraged, and it does provide the foundation for that and the framework in which we can support everyone in the public sector to come forward with the protections that it provides and certainly the obligations that it imposes. Without those two, it would be harder for people to feel safe and secure, and I suppose on a footing of feeling confident to come forward when they see or witness wrongdoing. So what have the returns kind of told us about, or what did we learn in terms of the first reporting period? We will discuss in a moment, but I just wanted to highlight that the first annual returns only cover a 9-month rather than a 12-month period, as would normally be the case, simply because the Act commenced in October of 23. Now, had these sessions been just a little bit longer down the track, we could have far more currency in terms of the annual returns, which the second year is under process at the moment, and the analysis stage would only commence probably in the month of September. So I think you'll hear a lot more in terms of data when we move forward with the second annual return. Patrick, I hand over to you.
So as part of their PID annual returns, agencies are required to include information about the measures that they took to promote a culture in which PIDs are encouraged. The fostering of a speak-up culture is really central to the success of the PID scheme, and we heard about that this morning during the panel discussions, and we'll hear about it throughout the week. So what has the initial reporting revealed? The annual returns data showed that 85% of agencies in New South Wales were taking measures to actively promote a speak-up culture. And while agencies often use more than one measure to promote a speak-up culture, the most common methods that were used were distributing PID material and making resources available to staff, holding discussions at all staff, branch and team or unit meetings, and incorporating PID awareness training into existing training sessions. So, for example, 73% of agencies indicated that they included content about the Act in their induction training. Some agencies also utilised some more novel approaches, and these included messages on pay slips about the importance of speaking up, and they also included screensavers with speak up messages. However, somewhat, I guess, disappointingly, 58 responses indicated that no measures were taken to promote a speak up culture.
I think I'm up next. We move on from awareness to training. So while a lot of agencies have indicated that they proactively promote awareness and the Act itself, what have they done in terms of the training and for those roles that have responsibilities attached to them? Now you can see on the slides there that there is some room, I would say, for improvement, but I suppose don't forget that this would have been June of 2024, so that may have changed certainly to the next reporting. But in terms of that very necessary training that people with roles and responsibilities, and I think, if I'm not mistaken, Commissioner Lowe mentioned this morning how important that was, particularly for managers. If someone does approach you and a manager doesn't know what to do with that report, it's not going to instill a lot of confidence, I think, in the public official coming forward. So it is important to highlight that not only is it an obligation for agencies to provide that training to their public officials, and particularly those that have a role with responsibilities, but also that there are tangible reasons and benefits for doing so. Now, from those graphs that you can see on the board, what we know is 67% of all voluntary PIDs were reported to disclosure officers. The highest number of training was undertaken for heads of agencies, and the lowest score at 59% was the managers. So the managers are the cohort that really need to uplift their training, and yet they are likely to be the ones that public officials would approach perhaps first. If they're comfortable with their manager, they may be the first contact point. So I think that tells us a little bit in terms of where there might need to be some focus on training moving into the future. There was also 15% of agencies, or 85 in total, that indicated that none of their staff in these roles had undertaken any training. So that is concerning, and we'd like to I suppose analyse some of that data that we'll receive this year to ascertain whether that still is the case or whether that has significantly improved from the last reporting period. It's an opportune time now, I suppose, to highlight that we do have training available at the New South Wales Ombudsman's office. If you need any material or assistance with that, please reach out to our engagement team and they'll happily provide you with some of those resources to ensure that you're better placed to meet those training obligations if you need them. From training, I suppose we move into the insights in terms of what the reporting looked like during those first 9 months. Chris Clayton mentioned earlier today that there was 1,330 voluntary PIDs that were reported in that 9-month period, and that was a completion rate with agencies of 97%. Some of the interesting data that came out of that 61% of those voluntary PIDs did relate to the Category 1, meaning it related to the agency itself or employees of the agency or the functions of the agency. And some 42% of those also related to allegations which involved more than one public official. So that's kind of something to bear in mind. There has been questions, and I think a really fundamental question about, given the increase in awareness and the increase in protections and the increase in training obligations, has all that translated into a greater number of voluntary PIDs or reporting that have occurred, which is a fundamental question. Now, given that we did have 1,330 in the 9-month period, people would very readily attribute that there was a significant increase if they compared that to the previous reporting period. So I'd just like to kind of, I suppose, emphasise some caution in trying to compare two very different PID schemes. So if you looked at that former report, you would have seen that there were around 400 odd agencies that reported approximately the same number of PIDs, around 404, but the two really cannot be compared directly. So I think the best information comparisons that we can make is moving forward when we compare like for like under the current scheme. Now you might be interested, and this too was covered earlier this morning, as to who do people approach more or first in terms of their reporting. So who were the recipients of these voluntary PIDs? 60%, according to the data, did approach a disclosure officer. I suppose we need to be mindful that managers might also be a disclosure officer, so perhaps we don't have that clear breakdown that we'd like to. 4% reported that they went straight directly to their manager, 7% to their head of agencies, and around 29% didn't actually list anybody at all, which the Act would then automatically attribute to the head of agency. Now, Patrick will just cover some topics in terms of what's important in that assessment process when you're receiving a PID, and also purported PIDs, because there has been, I think, some confusion around purported PIDs and the reporting of them. So I'll hand over to Patrick to discuss that.
Thanks, Marianne. Yes, just while we're talking about identifying PIDs, I wanted to talk briefly about the assessment process, because there are certainly a few things that we've learned since the 1st of October 2023. And something that's become apparent to us, especially in our PID scenario training, which is a new kind of training that we have delivered in the last year, more or less, is that some agencies are taking some irrelevant factors into consideration when they're assessing a disclosure. And in particular, they're thinking about how they're going to deal with the disclosure at the time they're doing the assessment, and that's not a relevant consideration. So as agencies will be aware, a PID a disclosure is a voluntary PID if it has the 5 features of a voluntary PID. And as I say, any consideration about how to deal with the PID comes at a later stage. As Marianne has mentioned as well, reporting has also revealed some confusion about what a purported PID is and about purported PIDs generally. So in essence, these are reports where the disclosure maker claims that their report is a voluntary PID. So they come forward and they say, I am making a voluntary PID. And it seems to us that some agencies are taking that claim at face value and accepting or identifying that the report is a voluntary PID without properly considering if the disclosure has the 5 features of a voluntary PID. So I only mentioned those briefly, but I think it reinforces the importance of agencies having a proper assessment process in place when they receive a disclosure.
Thanks, Patrick. We'll move on to the type of serious wrongdoing now, because there is interest in terms of what public officials are reporting in terms of conduct. So 59% of all reports in the last reporting period related to corrupt conduct, 26 to serious maladministration. So you can see the two total to around 85% of all allegations that we received in that 9-month period. Now, the changes that occurred in terms of reporting, and I think if you're involved in governance or anything like that, you will note that there's a lot more reporting under this current scheme. And that does also include having a capacity to report all type of conduct that might be alleged within the disclosure, not just the main or primary one, which would have been the case under the old reporting scheme. What we have noticed, though, that it appears that some agencies, if not most, they're still kind of just identifying that core or only primary consideration rather than all of them, because what we know is that most allegations of corrupt conduct will also fit within the definition of maladministration. And the fact that only 14% of the reports involve multiple categories, I think, is an indicator that perhaps agencies are still not encapsulating all the conduct that might form part of that allegation. And it is important information for us just in terms of gauging what's happening out there with public officials and that conduct. Moving on
we might just go back. I think we might have missed a slide there, Marianne, which is about dealing with different types of voluntary PIDs. There's some interesting information in here that agencies might be interested in. So I just wanted to talk here about anonymous voluntary PIDs and compare it with what we're calling de-identified voluntary PIDs. And I also just wanted to talk about deemed voluntary PIDs as well. So as many agencies will be aware, under the PID Act, a PID maker is not required to identify themselves when they're making their disclosure. They can submit an anonymous PID, or they may choose to submit their disclosure in a way that does not reveal their identifying information. Given this, it's important that agencies have an appropriate policy and procedure in place for dealing with anonymous and de-identified disclosures, as well as for protecting a PID maker. So what is the difference between an anonymous and de-identified PID? Well, if you're not sure, don't worry, you're not alone. We have learned that many agencies are really still not sure what an anonymous PID is, and it does have a very specific meaning under the Act. The term anonymous, so an anonymous in relation to a disclosure, means that taking into account the circumstances of the disclosure and the material accompanying the disclosure, there is no reasonably practical means of communicating with the person, even if their name is known. This means that the test to determine whether a disclosure is anonymous is not whether the agency or the person receiving the disclosure knows the name of the maker of the report, but rather whether there are reasonable or practical means of communicating with the maker. Consequently, you could know the name of the disclosure maker, but if you don't have a way to contact them, then the disclosure is anonymous. In contrast, a de-identified voluntary PID refers to a voluntary disclosure made by a public official where the PID maker's true identity is not disclosed, but they have provided some means of contact. An example of a de-identified voluntary PID is where someone uses an email address that does not reveal their identifying information, but of course enables ongoing communication. For the purposes of the PID Act, both an anonymous voluntary PID and a de-identified voluntary PID are voluntary PIDs. And what that means is an agency has an obligation to deal with them in accordance with the Act. The other category of PID that I just wanted to talk about was a deemed voluntary PID. And just to refresh your memory, this is a disclosure that does not have all the 5 features of a voluntary PID, but which the head of the agency has decided to deal with as a voluntary PID. An agency should be aware that if they deem a disclosure to be a voluntary PID, then they're required to deal with it in accordance with the PID Act. It seems fair to say that deeming a disclosure has many benefits, especially to the disclosure maker, but it also carries some risks to the agency, especially if they don't deal with the disclosure appropriately. Additionally, the PID Act has some very particular requirements about how to deal with a voluntary PID, and it won't always be appropriate or even necessary to deal with some particular matters in accordance with the Act. I just raise these because I think they're relevant things for agencies to consider when they're deciding if it's appropriate to deem a disclosure to be a voluntary PID.
Thank you, Patrick, and I'll just echo those points about the anonymous PIDs or de-identified. We did see within the reporting that there was confusion around that, and that considerations which were taken into account was normally the application of, I suppose, the ordinary meaning of anonymous rather than anonymous as defined in the Act. So I suppose just if you could be mindful of that, there are different meanings that apply in this context in terms of your reporting. So now we'll go into dealing with and how agencies had dealt with those voluntary PIDs that they reported last year. Of the 1,330 PIDs that were reported, almost half, or 735, were reported as finalised with outcomes. And I think Chris mentioned this morning that out of those, 81 matters were actually resulted in positive findings of serious wrongdoing. So that is not a small number, and if it were not for the public officials coming forward, many of these matters perhaps would not ever have come to light. So I think that signals the importance of people feeling comfortable and safe to come forward, because it does come out with tangible results and outcomes. In terms of how they were dealt with for corrective action with the findings, we found that 23% of them were dealt with under the GSE Act, whereas 37% applied the educational or training route to deal with those disclosures. And I think, Patrick, you were going to cover a little bit about corrective action and considerations to be taken into account.
Yeah, so I wanted to talk here about the information to be provided to a PID maker at the conclusion of an investigation. So Section 59, subsection 2F, provides that an agency which completes an investigation is to provide the disclosure maker with 1, a description of the results of the investigation, and 2, details of the corrective action that is taken, proposed or recommended. A question that agencies commonly ask us is what level of detail can I provide to the PID maker at the end of an investigation? And what about the information about corrective action as well? Because quite rightly, agencies are very conscious of privacy and confidentiality considerations. So the requirement to provide a description of the results of the investigation requires agencies to provide enough information to allow the maker to understand the outcome of the investigation into their disclosure. What should be communicated to the PID maker will need to be determined on a case-by-case basis and will depend on a range of factors, including the content of the original disclosure, the nature of the subject matter of the disclosure, and any privacy or public interest considerations. In our view, at a minimum, a PID maker should be provided with the following information: the aspects of their disclosure that were investigated, specific findings made, including whether the disclosure was substantiated, and actions as well as corrective actions that have been taken or are proposed in relation to the conduct of the subject of the disclosure. As for corrective action, if an agency has taken corrective action, it must provide the details of any action taken, proposed or recommended. Here, the Act specifically uses the word details, so an agency will need to provide more than a simple statement that something was done. We don't think that it would be sufficient to simply inform the maker of the PID that corrective action was taken without providing further information. At a minimum, providing details of corrective action requires informing the PID maker of the type of corrective action that was taken, proposed or recommended, and it may be relevant to provide further details. When determining what level of detail to include about corrective action, there are a range of things that an agency can consider. The first one is what type of corrective action was taken. Here, if the action involves something like agency reform, more information can generally be provided to the PID maker because it will not normally include personal information, and it will be more widely known within an agency. In contrast, if the corrective action involved action taken under the GSE Act, the agency will need to be more careful, especially if there's a risk of disclosing personal or health information. The second factor agencies should consider is what was the content of the original disclosure. If the content of the disclosure relates directly to the corrective action that was taken, it may be appropriate to provide more information. For example, if the PID maker was the person affected by the serious wrongdoing, it may well be appropriate to provide details about the corrective action taken, proposed or recommended. The final thing that the agency will need to consider is whether there are any legal or confidentiality issues that arise. And when there are, the agency may need to seek independent legal advice about whether it's appropriate to provide information. Going on then to the next topic, which is referrals to integrity agencies. An agency that receives a voluntary PID may refer the PID to a relevant integrity agency. And as we can see on this slide here, that happened rather frequently. In some cases, an agency will be required to report serious wrongdoing to an integrity agency because of an obligation that arises under another piece of legislation. For example, under Section 11 of the Independent Commission Against Corruption Act 1988, a principal officer of a public authority has a duty to report to the ICAC any matter where there is a reasonable suspicion that corrupt conduct has occurred or may occur. This obligation to report corrupt conduct to the ICAC is distinct from any action or decision taken under the PID Act. If an agency were to decide to refer a voluntary PID to the ICAC, in addition to its duty to report corrupt conduct to the ICAC, it should make clear in any covering correspondence that it is making a PID Act referral as well as an ICAC Act report. Just looking again at these statistics, so agencies reported that they made 159 referrals to integrity agencies. Of these, 110 referrals were made to the ICAC, and of those, 88 related to alleged corrupt conduct, and 26 referrals were made to the Ombudsman, and of those, 14 were reports about serious maladministration. All other voluntary PIDs referred to the Ombudsman were actually reports of corrupt conduct. In most cases, where voluntary PIDs were referred to an integrity agency, they were directed to the integrity agency whose ordinary jurisdiction is the relevant category of corrupt conduct.
Thanks, Patrick. Just chatting on that point, before we go to the integrity agencies, Patrick mentioned the importance of, I suppose, balancing confidentiality considerations relative to providing the information to the discloser. And that was discussed in this morning's session, if you can recall, that we should be shouting and praising the work that is done, and also providing the confidence to those disclosures that work is actually being undertaken, even though we don't have, or we can't provide as much detail in there. I think it's no easy kind of consideration where you get that balance, so just be mindful of your obligations in terms of confidentiality, but also the positive benefits of coming forward and engaging with them, and recognising that their disclosure was important. Thank you. Now, in terms of where the agencies that receive the most PIDs, it wouldn't be a surprise to you if you could just flick that slide for me. Thanks, Patrick. Where did most of the voluntary PIDs, where were they received, I suppose? Now, if you look at the kind of first three, certainly dominating at the moment, so 79%, or almost 1,050 voluntary PIDs, were reported to public service agencies, which sat at 31% of all voluntary PIDs, followed by, or closely followed by, integrity agencies at 26%, and statutory bodies representing the Crown at about 21 or so %. So I don't think that's any surprise to anyone. They're large agencies, and there is an expectation that that might be the case. In order to, I suppose, break it down or analyse it a bit more, as part of the annual returns, we do ask agencies to submit their FTE, or full-time equivalent employees, just so we can gauge how large they are relative to the PIDs that they receive. And out of interest, 13 agencies, which comprise 2% of all of the agencies that reported, with over more than 10,000 FTE, reported 41% of all of those PIDs. So I think that again aligns with, it's a large agency, there's a lot of public officials within the agency, it is likely to stimulate more reporting. The other factor in terms of the size of an agency, if we looked at agencies between the size of, say, 100 or 101 to the 1,000 mark, there were 167 of them comprising this cohort that reported, and they reported receiving around 404 voluntary PIDs, or 30% of all PIDs. So I think there's kind of no surprises there, but it's good to know, you know, where the PIDs are coming from. Are they larger, smaller agencies? Are there any concerns? And we hope to, in the future, be able to break that down a little bit more. I think that Chris mentioned earlier today that we did send out in 2024 and now 2025 2 self-assessment audits comprising a lot of questions, and we'll be able to analyse those results and get some trajectory in terms of how the obligations are faring, and whether the compliance with those obligations is in fact increasing, which is what we'd like to see. We hope to publish that report on the 2 self-assessment audits probably towards the end of this calendar year. So certainly I think you'll get a lot more insight out of that, and we'll flag it with agencies when that's about to be released. We'll move now on to reportable events. So it's not only that agencies need to report a PID annual return, and to do so within a prescribed period with all the information likewise prescribed in the regulations, but there are also reportable event notifications that are mandated by the Act, which cover 3 specific topics. So almost everything related to detrimental action, be it an allegation, be it a conviction, be it evidence of detrimental action, that it triggers a reporting notification to us, and that's not at a particular time, but it's as soon as reasonably practicable, which we define as soon as possible, basically. So as soon as you receive anything that remotely looks like that, it does trigger a notification to us. We do have templates at the moment that you can complete, and there is some change actually on that one, and I think Patrick will talk to that. The second group of that mandatory notification trigger are certain decisions that an agency takes. So any decision to cease an investigation or terminate or not even start, I should say, an investigation. So a decision not to commence or a decision to cease without finalising and not referring it to another agency, so effectively closing it, if you will, that triggers also a report to us. And please, again, do that as soon as you can or as soon as you're aware of it. And the third one, and these are the ones that we've received most of at the moment, are agency arrangements. And I'll just talk to that a little bit because I think there is an awareness with one of them, that would be an agency-to-agency agreement, where you can effectively delegate all your obligations to another agency and they do everything for you. Now, that being the case, you're also required to advise us of that as soon as possible. Over and above, you're required to publish the details of that arrangement. I think one that kind of falls off as an aside a little bit is the 81(3) arrangement, and that's where you can effectively delegate or enter into arrangement, but for only 3 things. So you can get another entity to do your training for you, they can receive your voluntary PIDs or disclosures, and they can investigate it for you. And what we have found is that certainly through the 55 section reporting, which is when they talk about an investigation, we've identified that a lot of agencies are using external investigators to conduct either full or partial investigations of the disclosures, but we couldn't see an 81 disclosure indicating to us that that was the case, that this arrangement was entered into. So I think we're likely to see a bit of an increase, Patrick, with those arrangements that entered into with entities, so an agency and an entity, specifically to undertake a particular investigation. They also need to be, we need to be notified of the same, but I don't think that we've got that correlation at the moment. So just please be mindful of those. In terms of numbers and what we've discovered last reporting period, we had a total of 126 notifications, again over that 9-month period. 53% of those related to the Section 81 arrangements that were entered into. Now, in terms of how we're faring this year, we've not published those results as yet, but I can certainly indicate that the detrimental action and the arrangements, entering into arrangements, had increased, and the Section 55, so related to the investigations, are on the decrease. So an interesting kind of trajectory there. Now, one thing we also recognise that it's not necessarily clear what the purpose of the notifications are and what indeed we do with them when we receive those notifications, so we thought we might just elaborate a little bit on that. Generally, and I suppose we may do a number of things, but principally we might request more information from you. That would obviously be the first starting point. We can intervene if necessary, and that's generally where something is not adequate, it explains, or something might look to be somewhat misguided, so we'll reach out to you. We also are there to provide assistance and help that you might need or want with these reportables, and we monitor how a disclosure is progressing, and they certainly provide us quite a bit of information that will be used as a data set, as intel, in order to formulate our programs moving forward. Patrick, I think?
I was just going to talk briefly about what happens when we receive a Section 34 or Section 55 notification, because they're the ones where we principally ask the most questions. And just to let you know that from the 1st of July 2025, the responsibility for those 2 types of notifications move from the PID Audit and Monitoring team, from Marianne's team, to the PID Advice team. And since that time, we've followed up with a number of agencies just asking them some questions. And certainly we don't want you to be put off if we have some questions for you. Really, we're just exercising our functions under the Act and just trying to understand those notifications more clearly. So firstly, talking about the Section 34 4 notifications. So these are notifications relating to detrimental action offences. And agencies are required to make those notifications where they become aware of an allegation of a detrimental action offence, or if they know that a detrimental action offence has been committed. And when we receive a detrimental action offence notification, we contact the agency for further information to understand, one, whether the agency is appropriately dealing with the matter, and two, the seriousness of the allegation. And this information in turn helps us to decide whether any further monitoring action might be required. As Mary-Anne sort of mentioned a little bit earlier in the presentation, we're actually revising the notification template for those Section 34 notifications. And our reason for doing that is we've realised that agencies are not entirely sure what information they're required to provide under those Section 34 notifications. So we're hoping to make that a little bit clearer with the new notification template. A question that often arises in relation to Section 34 notifications is what is the difference between detrimental action offence versus, an allegation of a detrimental action offence versus evidence of a detrimental action offence. And it's pretty clear, that the legislature has really tried to distinguish between those two things because it refers to those two things quite distinctly. In our view, an allegation of a detrimental action offence might involve a PID maker claiming that they have been the subject of detrimental action without additional supporting information. In contrast, for information to be evidence of a detrimental action offence, it should probably be something more than a mere claim or assertion. The information should be of a kind that could prove or support the claim that detrimental action took place. When an agency is trying to decide if it has evidence of a detrimental action offence, it may be helpful to consider, well, firstly, any claim or allegation that someone has been the subject of detrimental action, the meaning of the words detriment or detrimental action as defined in the Act, and if the alleged conduct qualifies as either detriment or detrimental action. If there is material that would appear to support the claim or allegation, and the agency should also look at the elements of the detrimental action offence which are set out in the Act. It's really critical too to note that an agency is not required to assess the probative value of the material that may support an allegation, and they don't need to form an opinion about whether the evidence is sufficient to prove a detrimental action offence beyond a reasonable doubt. Rather, if the agency has evidence of a detrimental action offence, it is required to provide that evidence to police and to either the ICAC or the LEC, depending on the circumstances. It's also important to point out that whether an agency is aware of an allegation of a detrimental action offence only, or if it has evidence of a detrimental action offence, it is required to notify the Ombudsman. I also just wanted to talk very briefly about Section 55 notifications. And it's just something that I wanted to point out that we actually have on our notification template, and that is that there is a difference between a decision made under Section 49(2) of the Act and a decision made under Section 55(3). And it's only those decisions that are made under Section 55 subsection 3 of the Act that are required to be notified to the Ombudsman. So in essence, a decision made under Section 49 subsection 2 is a decision that a disclosure is not a voluntary PID, where a decision under Section 55 subsection 3 involves an agency deciding not to deal with a disclosure that is a voluntary PID.
Thank you, Patrick. All right, that sort of brings us towards the end, I suppose. We're looking at what is next. Next slide. Covered that one, I think.
There is one other thing just to mention in relation to Section 55(3) decisions. And I just wanted to let agencies know that we'll shortly be updating some of the information in our model PID policy about when a person can make a PID to an MP or a journalist. And so this is to align the model policy closely with what the Act says about how a decision made under Section 55 subsection 3 affects a person's ability to make a PID to a Member of Parliament or a journalist. And agencies might need to or might want to look at this change when the model policy is published to see if they need to change their own PID policy.
Thanks, Patrick. I think you're making some changes to a few more policies, another 6, or not policies, but guidelines.
There are, yeah.
be aware that they're coming, and it's really, they're not fundamental changes, they're just more explanatory, and they're informed by the advice or information that we receive, and I suppose they inform the changes to ensure that there is enough information for agencies to be guided in how they perform their duties. Moving on from that, what is next? I suppose we're looking at, we've got that guideline reviews. I've already mentioned the 24 and 25 self-assessment audits, so I suppose hold out for those reports and be informed by what they say. We'll also be able to take an analysis of the PID annual return for the which closed effectively 30 June 2025, but we won't be starting that analysis probably around the September mark, because there are some agencies still in the process of submitting their returns. We're hoping to have far more information in that one and also release it probably toward the end of this year. There are new training models that are being developed as we speak, and as well as new awareness materials. I mean, this PID week is a clear example that one of the awareness activities that we do to promote awareness of the PID Act, but we've also got very specific materials that will cater to the local Aboriginal land councils so that they're tailored to their needs and the messaging that applies. Those that perhaps in the room might be part of the community of practice that we also have, and that there will be a session on Friday for those members. So we try and kind of promote that, and you can engage with your colleagues who are in like positions and share ideas and I suppose alternate methods or, learnings, what worked, what didn't work, and how do we progress further. We've also enhancing again the PID portal, and I'm surprised you didn't mention it, Patrick, because we're going to also put those notification templates on the PID portal. You do have some now, but with the development in process at the moment, we hope to make them more intuitive and more online. So as we kind of progress and evolve in terms of the feedback that we receive, we try to upgrade those I suppose, tools and resources that we have. So if you do have kind of any concerns or you want to give us some feedback, please, don't be shy, come forward. It leads to a better product and certainly easier to use and understand. So we certainly welcome all that.
We're certainly nearing the end of the presentation today. But the information that we have next is just about how we help agencies. And this won't be new to many people, but it's always worth repeating for people who might be new to PID. We have a dedicated PID advice team, which many of you have contacted and will be aware of. And we just wanted to remind agencies that you're always welcome to contact us with any questions you might have about the PID Act. And we're always very happy to help. Additionally, we do have published guidelines which are designed to help agencies to understand their responsibilities under the Act and to help staff who have PID Act responsibilities to understand those responsibilities. And as Marianne has already mentioned, we're in the process of updating 6 of those guidelines. And the reason for that is to add some further information about particular topics. And if you're at the PID immersion session earlier, we talked about internal review, and that's one of the topics that we've updated as an example. We also continue to offer training and workshop delivery. And as I mentioned earlier in the presentation, we now have some PID scenario training which agencies are reporting is very useful for the way that they assess and investigate PIDs and how they manage risk. And we have also training resources and videos available online.
Thanks, Patrick. And finally, a bit of a plug for our new service, the Whistleblower Support Unit. It is probably one of a kind at the moment, and we're trying to embed it down nicely. So any New South Wales public official who has made or is thinking of making or speaking up, making a voluntary PID, we have that service to assist you. So the service is independent, and you can contact them, I suppose. You've got the phone numbers there and the email address. If you want more information, there is a session tomorrow afternoon on day 2, and the manager of the whistleblowing support team will actually be providing a lot of information on that service and considerations around it. So please kind of tune in for more information about that. And I think we kind of end on that note, Patrick. We're more than happy to take any questions, either in person or online. If we don't get to any of those questions, we will certainly share the responses with you. So if there are any, please. Nick? Got to meet a few people today, which is very nice.
Thanks, Marianne. Just a question. You shared with us some stats, if you like, in relation to referrals to our integrity agencies. Just curious to know whether or not you have any stats that you can share in relation to, I guess, those referrals where adverse findings or serious misconduct was identified as a result of those public interest disclosure investigations.
Well, what we can, I suppose the only thing we can say is that they were referred to the agencies. Now, if they reported those as part of the PID annual return, they would already form part of those, say, 81 findings. I think what we also need to consider is how integrity agencies operate and whether they're investigating under their own powers, which then there are different thresholds for investigations, as you would be aware, and that may impact whether or not we have more information on that and whether the reporting would align to the, what we define as investigation under the PID Act. So they're quite different in terms of thresholds. But certainly if we do have the information, if it's reported within the PID annual return, we do report it publicly in our oversight report. So, and we do kind of separate them. Sorry, Nick. So, the referrals that did go to integrity agencies and those that didn't are reported on separately, just so you have a bit of granularity around that.
Thank you. Was just thinking it would be good to, I guess, see some thematic reporting in relation to system improvement, where operational risk on some of those systems were identified and what agencies have done to correct that risk as well, which could be learnings to be shared across agencies.
No, absolutely. That's a great point. And I think any learnings and sharing of them is fundamental to us all being better at what we do, better at what we report, more informed moving forward. So absolutely. And certainly any ideas or anything that in particular that kind of you may have come across, we'd be very interested in that. Any other questions? No? We might be good. We get an early mark. Look, thank you all very much. I appreciate it. It's sometimes hard on days like this to drag yourself in person. We're most grateful that you did. You have faces to names, and we're more than happy to take on any questions, engage with you further, and have discussions that would benefit us all kind of moving forward. So thank you all again.